don't go for something like that. And within the university system, no, I must place the union in proper pathway for people to understand.
Hello and welcome to the program. Now, just how do you solve a legal problem that is actually not expressly defined in the Constitution? That is the challenge confronting Nigeria and, of course, legal experts today over the Kogi State governorship election. Nigeria's election regulator, Independent National Electoral Commission, INEC, declared the election inconclusive on the grounds that no candidate has as yet won an outright majority. The commission says a supplementary election would have to be organized in 91 polling units that were initially cancelled to determine the winner of the election. But the man who was leading in the race, the APC's Abubakar Audu, suddenly took ill and died on the same day INEC declared the election inconclusive, now throwing the whole process into serious confusion. There has been argument by lawyers over what should happen next. INEC has actually asked APC to replace the late Audu Abubakar with another candidate, but that decision itself is generating another round of controversy, even within the APC that is leading in the race. Running mate to the late Abubakar Audu, that's Abiodun Faleke, is asking INEC now to declare him winner of the election, citing some aspect of the Constitution to back up his claim. He has, of course, given the clearest indication that he would head to court if INEC fails to declare him governor-elect. Of course, his stance runs contrary to the position of his party, the APC, which has said it would nominate another candidate in place of the late Audu, in line with the directive of INEC and, of course, that of the Attorney General of the Federation. Here is what the party national chairman, John Oyegun, said.
Things should develop from this stage on, and he has made a pronouncement to the effect that all that is required is for the APC to go through the processes of providing a substitute to our late mourned candidate. The implication, of course, being that thereafter, the supplementary elections to conclude the process of electing a new governor for Kogi State will then be put in place. So as a party, we are going to proceed with the process of organizing primaries to provide a substitute candidate to our late beloved Prince Abubakar Audu.
Of course, Mr. Faleke is having none of that. Writing through his lawyer, Wole Olanikpekun SAN, he said, quote, "In law and logic, no new candidate can inherit or be a beneficiary of the votes already cast, counted, and declared by INEC before that candidate was nominated and purportedly sponsored." End of quote. Going further, his lawyer wrote, assuming without conceding that INEC is even right to order a supplementary election, the votes already cast, counted, and declared on Saturday, 25th November 2015, were votes for the joint constitutional ticket of Prince Audu Abubakar and our client, that's Faleke. Therefore, no new or supplementary candidate can hijack, aggregate, appropriate, or inherit the said votes. End of quotes there. Mr. Faleke also wrote his party, the APC, asking it to comply with, not to comply with INEC directive, but rather support him as the duly elected governor of Kogi State. Now, the PDP has also added to the whole legal conundrum. Its candidate and incumbent governor, Idris Wada, of course, is trailing the APC in second position, going by the votes already counted and declared by INEC. But the PDP now says Wada should be declared winner of the election. It also cited an aspect of the Constitution to back up its position. Take a listen now to party spokesman Olisa Metu articulating the party's position.
Caucus completely rejects the decision of INEC in yielding to the unlawful prompting of the clearly partisan Attorney General of the Federation Malam Abubakar Malami, to allow APC to substitute a candidate in the middle of an election, even when such has no place in the Constitution and the Electoral Act. Insists that with the death of his candidate, Prince Abubakar Audu, the APC has legally crashed out of the governorship race, as no known law or constitutional provision allows the substituting of candidates once the ballot process has commenced. Caucus insists that with the unfortunate death of Prince Abubakar Audu, the APC has no valid candidate in the election, leaving INEC with no other lawful option than to declare the PDP candidate, Captain Idris Wada, as the winner of the election.
Joining me on the program now to discuss the Kogi legal conundrum further is Mr. G.T. Ogunye, who is a lawyer. Mr. Ogunye, thank you very much for joining us on the program. First of all, what do you make of the letter now written to INEC by the deputy governorship candidate of the APC, James Faleke, asking INEC to declare him as the governor-elect?
Well, the position canvassed in that letter is indeed an adoption of my position that I canvassed earlier in the public domain. I had written in Premium Times about 5-6 days ago that that's the course of action that ought to be taken in the circumstances. Because I took the view, and I still maintain that view, that it was wrong of INEC to have declared that election inconclusive. Why? Because at the time they did so, Audu had apparently been elected using all the parameters. He had won 16 of the 21 local governments, securing in these local governments at least 1/4 of the votes, and he had a majority of the votes, beating his closest rival, the incumbent governor, Idris Wada, by 41,000 votes. And therefore, in the circumstances, it was wrong of INEC to have held on to an imaginary votes of 49,000 registered voters, as distinct from accredited voters and voters who had their PVCs, whose numbers were lower, far, far lower than that 49,000 registered voters, to thwart the election and stalemate the election. Indeed, I was expecting INEC, I haven't realized the damage that had been done by that deliberately created stalemate, to go back and then apologize to Nigerians and then declare the results as they were, so that any party or candidate in the election who was dissatisfied will then go to the election tribunal, Kogi State Election Tribunal, to ventilate his grievances. So for me, the position canvassed in that letter is in sync with the position earlier canvassed in the public domain.
But what do you make of those who argue that what the Constitution and indeed the Electoral Act actually says, that that the Constitution and the Electoral Act actually talked about registered voters and not actually accredited voters or the people with PVCs?
No, that's not true. There are a lot of misinformation and disinformation in the public domain on this subject. It's from the abundance of legal knowledge that the mouth speaks. I'm very clear about what the issues are. Section 33 of the Electoral Act provides that it's only in the event of withdrawal of a candidate or death that a party shall have the right to substitute his candidate. And then in Section 36, you have a provision that if a candidate in an election dies, before the commencement of poll, between the delivery of nomination papers and the commencement of poll, then that party can substitute his candidate. In this case, poll had commenced and the election was almost concluded. And so at that time, material time, it was no longer open to anybody to say that they wanted to substitute the candidate. And therefore, if you had a situation in which the Electoral Act provides for substitution before an election, and you then have a provision of the Constitution under Section 181 providing for a situation in which a governor-elect or deputy governor-elect dies before inauguration. So what then happens in the course of the election, or when results have been declared, barring this so-called supplementary election, what happens? Do you cancel? Section 68 of the Electoral Act says that once you declare results, you can't cancel. Do you substitute? Section 36 of the Electoral Act, in combination with Section 33, provide the timeline for substitution. So what then do you do? So you can't cancel, you can't substitute. What you do is to continue that election as if nobody had died, because what is not prohibited is permitted. That's a legal principle. If there is no express prohibition of an act, there is a permission of that act. And so there is no provision in the Electoral Act or in the Constitution that prohibits the continuation and conclusion of an election where a candidate died midstream, particularly at the tail end of the process. So what INEC is expected to do is to conclude that process, declare the results, and then the provision of Section 181 will take effect. If any party at all agrees with that position, is dissatisfied, they go to the tribunal. That's the rule of law that I know, not the rule of the thumb by which INEC will indicate that is allowing a party that no longer has the power to substitute, or for the Attorney General of the Federation to say that he has read Section 33, apparently in isolation of Section 36, and he has read Section 221, and the community reading of that will mean that APC has the power to substitute. That's the wrong reading of the provision of the Constitution, because Section 221 of the Constitution does not talk about substitution. It only talks about no association, which is not a political party, shall canvass for votes. So it has no bearing on what we have at hand. So the analogy I can use is that if you have a twin engine aircraft that, and there was a flight, say from Lagos, a plane to Abuja, and 5 minutes before touchdown, one of the engine packs up. What do? You abort the flight or land. You have to land with one engine, okay? Or you are conducting an examination, and there's a provision or examination guidelines that if any candidate in that examination were to die before the commencement of that examination, then the date will be shifted to accommodate the group that that candidate in that examination represents, to produce another one. And there is no provision to the fact that in the course of the examination, that the examination could be stopped for whatever reason, even if any of the candidates were to die. So if you have a candidate who indeed are written all the papers, as Audu are done, voting in the same election, and then results are released, so will the examiner or examining body then say, oh, because that candidate had died anyway, so we are going to nullify the entire exam. So that's the analogy I can use, and I have said that the legal path we've advocated is the path that is consistent with the rule of law and justice in this matter. Those who are arguing that Section 181 will not come into effect because the election is still inconclusive, they are not reading the provision of the Constitution with a clarity of mind that this situation requires. I've just said that you have three situations: before election, during election, after election. Before election, you can substitute. During election, there is silence. What do? You can't stop. the votes that have been gathered cannot be cancelled, as I've said. What do? Do you then substitute to bring somebody else to come and inherit and sow where he has not, and reap where he has not sown? You don't do that. Do you bring the son of the deceased to come and inherit the votes as if it were a dynasty or a monarchy or an oligarchy? No. So what do you do in the circumstances other than for INEC to extricate itself from the election as an umpire, declare the result as it is, whether without the supplementary election, as I've argued, or with the supplementary election, and then say, hey, parties, if you are dissatisfied, go to the tribunal. We have another election to conduct. That is the way. INEC has no business to be interloping and to be aiding a party to say, go and bring a candidate. It is past gone that period. That's the position I'm saying, and I won't allow any local particularities, any local ethno-religious configuration, any local sentiment on the ethnic group that could govern or the one that could not govern, any notion that somebody is a stranger, is just coming from someplace, to becloud my sense of justice and judgment. I am saying that, you know, when the maxim of the law says that let justice be done, even though the heaven falls, the heaven will not fall. And so once you do that, you've vindicated the rule of law. You cannot cancel the votes. The law does not allow you. You cannot substitute. The law does not allow you. What do? Continue with the election, declare the result, let the satisfied parties go to the tribunal. That's what the part that of the rule of law dictate.
The way it is now, if INEC does not reverse itself, as Faleke is asking it to do, what option do you think will be left to him?
That is exactly the issue, and that's why I call all this a comedy of error. Look, if INEC does not backtrack, APC does not backtrack, you then have a variant of the Amechi situation. Because it's going to go to court, as is threatened, serve a legal notice and say that, sorry, I've been robbed. This is a joint ticket. These votes were jointly won. That is even wrong for anybody to be saying that those votes belong to Audu alone. Okay, even if it is members of his family that voted, it's joint votes. And so somebody is being brought to come and reap where it's not sown. Two, and that person, because I don't know what they want to do. What is it, a hybrid situation? So what are you going to do? So you bring a candidate to substitute as the leading candidate of the APC, and you say, Faleke, you remain the deputy governor. So how are you going to manage that? Or you say, okay, this new person that is coming, because he has the right to pick his deputy anyway, so Faleke, go and rest. So we bring a deputy. I say, you're creating more problem than you tend to solve. They are playing politics. They are not concerned about law and justice. And I just wonder why expediency must trump reasonableness. The option available to him is to say, okay, I've accepted what you said, party supremacy, party dictatorship, so I won't contest anything any further. Or for him to then say, look, this cannot be the situation. Or for even electorates in that area to say that this is not what we voted for. Those votes were only meant for this new person that is coming. To say that they also want to litigate in the circumstances. So you then have a bedlam of a situation. You now have a PDP saying that it wants to go to court. They ought to have been declared. It's an act of God. So the candidate had died. So they should be the ones to be the winner now.
Exactly. I was going to ask you to react to that as well.
You say?
I was going to ask you to react to the PDP's position on this as well, saying that their candidate should be declared the winner since the other candidate has died.
You know, this is just unnecessary. How can you so claim? Look, how are you going to be declared as the winner just because that candidate had died? Just look at it this way. The candidate that is saying that they had died won 16 local government. He got at least one quarter of the votes. in 16 of the local governments, more than 2/3. In addition, he has the highest number of votes in the election. Now, a candidate, the incumbent governor, that was only able to muster 1/4 of the vote in 5 local governments and has not even accomplished the requirement of Section 179 of the Constitution, has not accomplished what Section 69, provision of Section 69 of the Electoral Act provides, because you must have won the popular vote, i.e. the highest number of votes, and at least win no less than 1/4 of votes in each of at least 2/3 of the states. So how is it going to be declared? That means it's no contest. Audu is dead. You have not qualified. You have not met the constitutional requirement. So let's start the fresh election. It's preposterous. It's absurd for them to even be fishing in troubled water and be saying that declare, you're going to be declared. Because you have not even fulfilled the constitutional requirement to be so declared. But, you know, the sense I make of all this rigmarole, of all these opportunistic interventions and declarations, is that when you've created an enabling environment for mischief to thrive, you then see this kind of thing. That's what INEC did. INEC had no business doing that. You know, INEC ought to have declared the results regardless of anything, and then allow the law to run its course. So if partisans disagree, INEC will have removed itself from it, and the federal government wouldn't have been brought into it, as it has now been brought into it, when an AGF that ought not to have spoken on the matter then started intervening by interpreting subjectively what the law says and what the law has not said. And for those who are talking about Section 33 of the Electoral Act, you know, knowledge makes one to exude confidence that some people may regard as arrogance. When people were talking about that Section 33, I just shook my head. Because you see, there are so many emergency public affairs analysts now and lawyers who are just talking all sorts of gibberish. I'm telling you, Section 33 of the Electoral Act was specifically provided to arrest a mischief. During the Obasanjo's years, there was something that was very common, which played out in Amechi's case. After the submission of the name of candidates, party supremacists and warlords at the headquarters of the political party would change whimsically the names of the candidates so submitted, so that all the politicians were now running helter-skelter, even bribing them not to change their name. It became so rife. And so, even in the ruling party, the PDP, politicians, members of the National Assembly, felt that, this problem must be dealt with. And so, Section 33 of the Constitution has to come. That whereas in the previous provisions of the Electoral Act, 2004, 2000, 2006, it was permissible for a party to change its candidate at any time. They then inserted that section that no party, after the submission of the names of candidates, after nomination, shall have the right to change the name of his candidate, except that candidate withdraws or that candidate dies. That is what that provision is talking about. Now, that provision is what the AGF is interpreting misleadingly to say that a party has the right to change a candidate in the course of an election. And so, for people who do not have knowledge of this history, who do not even care about the intendment of those provisions, they just begin to ban the provisions and say, where is this thing coming from? I get amazed and amused at the same time. What the law provides are clear. Before commencement of poll, if your candidate dies, and that's Section 36. Section 33 does not even apply. Section 36, if your candidate dies, on the eve, if Audu had died on Friday, if Audu had died 4 a.m. on Saturday, the officer, the resident electoral commissioner, and the returning officer have the right to countermand the poll and say, a candidate that died. So what we do is that we are going to postpone the election for 14 days. That's what the law says. But once the poll commenced, that right is extinguished. You can no longer change that candidate. And since the law does not have any provision prohibiting the continuation of that election, you have to continue that election. The umpire has to do so as if no candidate had died and declare the result. Because the danger of what they are trying to do, and I'll tell you, is that if you look at the Niger Delta, when this kidnapping started, people with fairer skins were the ones who are being kidnapped. Now, it has become a national problem. In fact, it's become an emergency. Boko Haram is even kidnapping. You know, everybody is kidnapping and all that. So once you make it a rule that once an election results are declared and that the winner had not been returned, which is the only thing that is left, but that once that candidate dies or anybody dies, who is a candidate, because in Kogi State, don't forget you have 22 candidates, that the election will be truncated and then you can start afresh. You know what the Nigerian political class will be doing? A class that killed a sitting attorney general, a class that killed a governor, somebody who wants to contest, like Williams, future Williams, they will go and kill one candidate. That's the end of that election. I'm telling you, and these people who are just saying this are not reasoning, just because of their own myopic view. You don't do that. You create more problems than you intend to solve. Because I don't want any candidate to die. They will just go and kill one. Out of 22, you must see one to kill now. And that's the end of that election. So it starts afresh. We warn them. They shouldn't do this kind of nonsense. What the law expects is that once poll had commenced or poll had closed, results have been declared. Declare their results. And then the party that has won, who has lost a candidate, will then take advantage of that. I give you an example. And I don't wish him dead. If Faleke, unfortunately, had been the one that died, so what will people be saying? Because it's a joint ticket. And the law also provides that you must replace him. So you then say that, okay, until he's replaced, because his nomination will no longer be valid. Because the law says, Section 187 of the Constitution says that before a nomination can be valid, you must have a deputy governor on the ticket. And so those who are talking about abortion of pregnancy is an aborted thing and all that, who are talking all sort of nonsense, pardon my French, would they then say at that stage that, okay, since two of them must be there all the time, so election must be cancelled, or there must be substitution before the continuation of the election? I know they won't say that. So don't argue for today. Argue for all times. Don't argue because, don't argue your whims and caprices or your personal predilection or your biases. Argue the law, argue common sense, argue logic. That's all I've striven to do as a publicist. And so, because you see, you may think that people are not taking notice of what everyone is saying. People do take notice of this. The way I see it is the way I said. And when I intervene somewhere else, people are asking me thereafter. But right from day one, people are talking about cancellation. Somebody talked about substitution. Why is it that nobody is saying what you are saying now? I say, we are not bound to reason the same way. We're not bound to reason the same way. That is what the law provides. Look, I'm trained to find the will of the law. Just as Christians will say that, yes, they want to find the will of God and purpose of God for their lives. I'm not trained to find the will of a politician and say, okay, what will favor this one and all that. I say the way I want to see it. And believe you me, it amounts to abuse of the right to freedom of expression and the right of the public to know, for you to come on air and then argue your biases. You're insulting people. That's not what people want to know, because people really want to be enlightened. They see a quandary, they see a logjam, they see another impasse, they see a putative or an incipient June 12th conundrum, and they really want to get out of it. They want to listen to you to know whether there is indeed a way out. And so you abuse them and you insult them even when you come and start saying the things that the law doesn't expect you to say. So that's the rule of law that I know. Do it according to how it's done. Don't allow extraneous consideration of, will this person be acceptable? Will it just saunter into the governorship by default like that? Will he do this? That is not my problem. Because people are saying that, the law has not allowed this. I laughed. I said, look back. When Yaradua was ailing, did the law allow Jonathan to succeed him? Why did it become so problematic? So it is not because, according to them, the law has not provided. It is because people are using their whims and caprices to frustrate. On that occasion, even when the law was clear, we were held to ransom in this country by what the media was calling a cabal then. We didn't know where our president was. So the legislature, everybody in the country was held to ransom. So much so that the National Assembly had to intervene. Before they would intervene, what happened? People had to nudge them. The same Nigerian group and other organizations had to come in. Was it because the law was not clear then? Was it because the Constitution has not provided? No. So those who are using the pretext that the law has not made any specific provision to bring about this mischief are not doing right by the Nigerian people. In any case, what is in an election? One office election. It's not even a general election. One office. And then you bungle it. This is your first outing since the reconstitution of INEC. This is the first outing in the life of this administration. This is the first outing in the life of an attorney general. And you bungle it, and then the entire country is just debating this thing now for 2 weeks. Fuel scarcity is hitting hard. The economy is not recovering 6 months after. And a lot of things are still wrong. Power is still a problem. The Naira is almost dying. And so these are the issues that we should focus, not to be distracted by this, whatever, and all that. So I hope that common sense will prevail in the circumstances.
All right. Mr. Aguiye, thank you very much for your contributions, and I like your passion about this.
Yeah, thanks so much.
Yeah. All right, we'll take a short break, and when we come back, we'll have more input from another lawyer. Every day, every hour, and every minute, news break in Nigeria. Things happen so fast, it's most times difficult to track and comprehend them. But that's what we do right here on DEJI360. 2015, would you want to come back again?
It's like asking Jesus Christ if he knew he was going to die, will you want to come back as the savior of the world again?
We do not just help you track the stories, we break them down, explore all the angles, analyze the issues so that you can fully comprehend the stories and use them to make the right decisions.